Your lawyer has suggested that you mediate your case and try to resolve the dispute with the other side through this negotiated resolution in the form of a mediation. What do you need to know about mediation? Well, typically in my experience, a mediation is a very good idea. I've settled over the years that I've been doing this many more cases through mediation than I have settled outside of a mediation. Mediation is an organized negotiation where you involve a neutral third party who's not on anybody's side, who tries to help you reach an agreement. A big part of what the mediator does is keep people talking, because often there are points in the negotiation where one side or the other gets mad and wants to walk away. Often that can happen early on. The one side demands tons of money, the other side offers virtually nothing, and both sides are tempted to just walk away. Part of the mediator's role is to keep people talking, to try to get those numbers to overlap, to try to get the plaintiff to demand less and the defendant to offer more until the two numbers cross. The mediator will try to help process the two sides' issues. Will, in a large way, give both sides an opportunity to be heard. A lot of resolving a dispute is letting both sides feel like their side of the story has been heard by somebody. And that's important all by itself, and a mediation offers that opportunity. Nobody can force you to settle a case in a mediation. If you don't want to agree, the mediator can't and won't try to make you agree. I think a good mediator will offer you very good reasons why you should agree. A good mediator will tell you, I think, the weak points in your case, and will do the same thing to the other side as the mediator tries to move you closer to a resolution. And that's useful. One thing that you get out of a mediation, even if you don't make a deal, is you get to hear what the other side has to say. You get to hear what they think their strong points are, what they think your weak points are. And preferably you'll get some indication from the mediator as to what the mediator thinks your weak points are and what the other side's strong points are. And that's useful. Even if you don't make a deal, going through the process will teach you things, will make you think of things that will be useful in terms of later fighting your way to a resolution in a courtroom dispute or in arbitration. So I typically favor trying to mediate a case. One of the things to think about is whether you should do it earlier or later. If you think you really do have a legitimate shot at settling the case early on without spending a lot of money on the litigation, that's usually a good thing. But sometimes it can't be done until you have done enough work talking to witnesses, taking depositions, doing the written discovery to understand your case well enough to know what you should settle for. There's an old saying that you can't settle a case until you're ready to try it. And there's a lot of truth to that. If you don't know how much you should be willing to pay or how much you should be willing to accept, it's very difficult to make a deal. And sometimes the litigation process will put you in a position to make a deal later rather than sooner. Sooner is better if you can do it, but sometimes it has to be later.